Welcome everyone, and thank you for joining us for today's webinar. We hope that you're all safe and healthy, and we appreciate you taking the time to be here with us today. You'll be able to participate in a live Q&A at the end of the webinar. So if you have any questions during the presentation, please type them into the Q&A area in your Zoom control panel. And if you miss anything, please don't worry. We will be sending around a link to the recording session when it's available. Throughout the webinar, you'll see poll questions related to the webinar topic. Because this is not a live session, but an encore presentation of a previously recorded session, the polls you'll see are not live. However, you will have the opportunity to independently answer the question presented in your own notes to test your own knowledge. Then check your answer against the correct answer presented. Remember, if you have any questions throughout the presentation, please do feel free to type them into the Q&A area of your Zoom control panel, and we will take the opportunity to answer them via text. We won't be stopping the recorded presentation to answer live questions, so please don't employ the raise hand function, but we will either type answers to your questions as they come in, or our national real estate expert will answer them at the end of the session once the recording is complete. My name is Jennifer Sterling, and I'm an instructional designer at the CE Shop, the leading provider of online real estate education. Today, we're covering titles and deeds as the topic relates to your real estate licensing exam, presented by the VA Real Estate Board pre-license instructor, Gail Glassmoyer. Gail comes to us with many years of experience within the real estate industry in Virginia. She's a certified VA Real Estate Board pre-license education instructor and owns her own career services consultancy, Glassmoyer CMS. Now, without further ado, we'll turn it over to Gail.
Hi, everybody. Thank you for joining us today. Today, we are going to be talking about title, and we are going to be talking about deeds. And title is going to be 8% of your test. So, transfer of title. So, today we're going to be discussing deeds, the elements of a valid deed, types of deeds, title, transfer of title, recording of title, and priority, as well as many other things. There will be questions throughout this recording, so please feel free to write the questions down, answer them on your own paper, and we will go from there. There's no need for you to put anything in the chat box. As Jen had mentioned, feel free to put any questions in your Q&A, and we will go from there. So, let's start talking about elements of a valid deed. These are all the things that go into a valid deed. You need to have the grantor, which is a seller. You need to have the grantee, which is the buyer. It will have a granting clause. It will say, I, Gail Glassmoyer, grant this house to blah, blah, blah. It will also have consideration. And if you notice, I put dollar signs next to consideration. It normally says consideration is money. That is true. And in real estate, that is what we use to purchase houses. But it could also mean love and affection. I don't think anybody is going to love and affect me so much they give me their house. So when they say consideration on a test, they are talking about money. Habendum clause. Habenda means to have and to hold. As a matter of fact, one of my students calls it to have, H-A-B, and to hold. To help her remember, the habendum clause means to have and to hold. It also needs to have a legal description of the property. Now, an address is not enough to be a legal description. Why? Because addresses change. The legal description of the property is going to be a meets and bounds description or a lot and block description and or a government rectangle system. It'll have one of those. That will be the legal description, the full description of the property. It will also have the signature of the grantor. So a question on your test might be, whose signature needs to be on the valid deed? Only the seller's signature needs to be on the deed. the grantee, the buyer, needs to have their name listed, but the seller is the one that actually signs the deed. It also means acknowledgement. Acknowledgement means notary. So if you're ever taking a test and they bring up the word notary, they're talking about acknowledgement. Why does it need acknowledgement? Well, the grantor we must make sure that the grantor's signature is valid and it is not forged. If it was forged, it would be a void contract. So in order for it to be valid, it needs to be acknowledged by a notary. And they will have one at closing. The most important thing is it needs to have delivery and acceptance. Delivery by the grantor and acceptance by the grantee. So here's a question. Which clause in the deed begins with the words to have and to hold? Well, if you said habendum clause, you are correct. And if you remember to have and to hold, that might help you answer a question like that. A deed is proof of ownership. Think about this one. Well, what do you think? I did this morning with my students in class, and I asked them, is a deed the proof of ownership? And you know what? Most of them got it wrong. They all thought it was true. But a deed is not proof of ownership. Why? Many people can actually have a deed to the property who have owned it over the lifespan of the property. What is proof of ownership? It is title insurance. Title insurance is the best evidence of title and proof of ownership. Why? Well, when you buy a house, you are going to take out, most likely you'll spend a few $1,000s and take out title insurance. Title insurance insures you backwards to the beginning owner and basically says that there can't be any other owners that own this property. You are the rightful owner of the property. It's kind of like home insurance, where you buy home insurance to insure you forward in case there is something that happens to the house. Title insurance actually insures you backwards to the original owner, so nobody's heirs or relative can come out of the woodworks and say, oh, I actually own the house. No, you are paying for title insurance so that the title company will literally have done its job, have looked through all the information in the deed, and will protect you against any unknown defects to the title. So God forbid somebody came out of the woodworks and said, oh, this house is actually mine. They will pay for your lawyer's fees, and they will basically pay for any fees that you've had laid out. That is what you pay title insurance. So if you ever get a question on the test where they say to you, what is the best evidence of title and proof of ownership? You are going to say title insurance. So let's talk transfer of title. It's either voluntary, meaning you did it on purpose, or it's involuntary and it is not your choice. So voluntary is during a person's lifetime. Either you're giving it away as a gift or you're selling the property. Involuntary can also be during your lifetime, but it is not your choice. It is usually carried out by operation of law. So involuntary alienation could be something such as eminent domain. Eminent domain is the government having the right to actually take your property. They have to pay you for it, but they could take your property and use it for public use through condemnation. Condemnation is the process. Eminent domain is the actual right of the government to take your property. Foreclosure, you don't pay your taxes, you don't pay your mortgage. they will take your property. That would be foreclosure. And a sheet, okay, a sheet, you're dead. Yeah, I get that. It is when you die with no heirs and there's nobody to take your property, then what happens? It's going to fall back on the government. That's maybe not what you had intended for the use. And adverse possession, we all know adverse possession is when somebody takes over your property. It is not your choice, but they're living out in the open and everybody knows that they're living there. So you haven't visited, you haven't used the property, so they have the right after so many years to file and take your property away from you. So when it comes to title transfer, it's either voluntary or involuntary. Here are some common deed types. There are 4 of them. Now, on a test, they may say to you, which has the most warranties? That would be the general warranty. They may even say to you, which has the least warranties? And that would be the quitclaim. Quitclaim has no warranties at all, and we're going to discuss that in a second. Special warranty has 2 warranties, and a bargain and sale has 1 warranty, but it's more or less implied. So let's talk about quitclaim. If you ever see cloud on title, it basically means that there's a small issue, a minor issue on the deed. Let's say, for example, I wrote my client's name as Stephen, S-T-E-V-E-N, on all the paperwork, and we get to closing. Well, are we going to close? Absolutely. However, his name is actually S-T-E-P-H-E-N. So I will have to file a quitclaim deed to correct that. So if there's a minor issue, unreleased gap, defect, something minor that could be easily taken care of, they will use a quitclaim deed. So again, cloud on title, think to yourself, quitclaim deed for a test. If they actually have to go to court, they would do what's called a suit to quiet title. Suit to quiet title is just that they're going to court to take care of it, as opposed to just filing a quitclaim deed. And if there is an issue with the title, it's usually found during a title search or abstract of title. So as far as the covenants for the general warranty deed, there are 5 covenants. Covenant of seisin, further assurance, against encumbrances, quiet enjoyment, and covenant of warranty forever. If you wanted to know what was on the special warranty deed, it would be warranty that grantor received title, warranty that property was unencumbered by the grantor. The bargain and sale deed is an implication that the grantor holds title and possession. And we all just talked about the quitclaim deed, and the quitclaim deed basically takes care of minor issues. So here's a question. Which deed type will most likely be used to clear a cloud on? That's right. If you said quitclaim deed, you are correct. Let's talk about recording. Recording is really important. You see all those files. Nowadays, everything's pretty much on the computer. But what does a recording do? Recording is placing a document into the land records, meaning the county courthouse. All records get placed in the county courthouse in which the land is located in. It gives 2 things: notice to the world, and it establishes priority. Now, priority does 2 things. It is the order in which the documents or liens are recorded, as well as the order in which claims against the property get paid off. So, first of all, when you go to the government center to record something, you walk in and the lady behind the desk has her little stamp and she goes, "Ker-chunk." And what happens is it stamps it with the date and time. So everybody knows when you actually recorded something. Now, let's say you take out a mortgage on your house. That is going to be the first lien against your house. Priority is first come, first serve. So first lien would be your mortgage. Second lien would be maybe, let's say you take a home equity line of credit out, that might be your second. And let's say you had a debt build on your home, but you decided not to pay the developer or the construction person. That could be a mechanics lien, that could be your third lien. Okay, well, priority is mortgage, home equity line of credit, and mechanics lien. That's the order in which they were recorded. But you might see on a test them ask you about priority, and they might talk about it's the order in which they get paid off. So you go to sell your house, your first mortgage gets paid off first, home equity line gets paid off second, and then your mechanics lien gets paid off third. There is an exception. The exception is taxes. So let's say you don't pay your taxes and or there is a special improvement done. You may get specially assessed for a new stoplight in your neighborhood or a speed hump or maybe a stop sign. All of those are special improvements. They also fall under general taxes. They always move to the front of the line. Taxes always get paid off first. So when we're talking about recording, we're talking about giving constructive notice, that is notice to the world. It's information that is there for you to learn. So recording a document or taking possession of a property both give notice to the world. So basically, whatever is presumed to be with the paperwork is you've gone in, you've given the paperwork to them, they go ka-chunk, they file it. It's there for anybody who decides to go take a look. Which brings me to the next topic, actual notice. Actual notice, I like to call eyes on the prize. Why? It means you have actually gone down to the county courthouse and actually have looked at it with your own eyes. So eyes on the prize is actual notice. You have literally gone down to the bowels of the county courthouse and gone through their computers to find and actually see the information. So constructive notice, whatever is supposed to be there, you are presuming that it is there, whereas actual notice, you have seen it with your own eyes. And we talked about taking possession of a property. So let's say, for example, you bought a property and were so busy moving in, you forgot to record, but you moved in and you took possession. Taking possession of the house also shows constructive notice, and eventually you'll get around to recording the document. But if anybody ever went to look, yes, you are living in the house, so you have given constructive notice. Let's see. A deed cannot be recorded unless it has been hopefully you mostly got all the answer right, and that would be acknowledged. Remember, we talked about the deed. They have to acknowledge it. A notary has to stamp it and make sure that the grantor's signature is valid and make sure it is not forged. Why? If it is a forged signature, it would be void and it would not be valid. Very good. Which of the following best identifies the importance of recording? Well, if you said B, you are correct. It gives the proper notice. Very good. Okay. First, let me talk about trust before we even get to deeds. So if you look at the picture, we have the grandfather, we have the mother, which is his daughter, and we have the child, the grandchild. So in this picture, the grandfather is the trustor. The mother would be the trustee, and the grandchild would be the beneficiary. So in this scenario, grandpa decides he wants to leave his house to the grandchild, the beneficiary. But what does he have to do? He needs to put it into a trust, and he is going to ask his daughter to be the trustee. He wants to leave the house so that the grandchild can actually go to college, and God forbid something happens to him, the daughter can actually sell the house and give the money to the beneficiary to pay for college. That's the scenario in a trust. So grandpa is the trustor, the mom is the trustee, and the child is the beneficiary. So let's say grandpa doesn't make it and he passes away. Well, the daughter goes into action, and the daughter will sell the house so that the proceeds can go to the beneficiary, the child, and the mother would actually use a trustee's deed. Why? It's not her house. She was not the original owner, but because it's in a trust, the mother would use a trustee. A deed executed by a trustee is called the trustee's deed. Now, let's say grandpa makes it and the child grows up, goes to college, pays for it themselves. Grandpa's happy. The mother now is going to take the trust and give the house back to the grandfather, her father. She will use what's called a reconveyance deed to reconvey it back to her father. So used by a trustee to return the title to the trustor. So here's a question we didn't talk about. Which deed conveys real estate to a trustee on behalf of the trustor for the benefit of the beneficiary? So what does this say? Which deed conveys real estate to a trustee? So basically, it's the deed that goes to the trustee from the trustor, the grandfather, for benefit of the beneficiary. Take a guess if you could figure out which it is. The answer would be deed of trust. So when grandpa gives the trust to the daughter or puts her in charge of the trust, he will use a deed of trust. So there you go. You have all three different ways. Chain of title. It is the record of property ownership from the grantor to the grantee from the first owner. So it is everybody who ever owned the property going backwards, okay? Abstract of title is going to show up one of two ways on a test. Usually it'll have the word summary or condensed history when they ask you a question on the test. So abstract of title means somebody from the title company went down, looked at the deeds, and literally went through every piece of paper and created an entire report. The report could be 200 pages long. Do you want to go through that? Probably not. So what they do is they do a nice little bulleted sheet, maybe not bulleted, but it's a very quick overview, condensed history or summary of everything that happened to that title. It's everything affecting the title throughout its history. I don't know about you, but I would rather read the Cliff Note version rather than the entire book of World and Peace. So abstract, you're going to see two words, summary or condensed history. Marketable title. Everything comes down to this. When you sell your house, you basically want to give to the buyer good and marketable title, saying that there's no issues with it. It's free of significant defects. Nobody could claim it's their house. And basically, the buyer can actually sell this home for full value as long as they disclose the fact and there are no issues. So at the end of the day, when you sell a property, you would like to give the buyer marketable title to the property. It's kind of like buying a car. If you buy a car, you want to turn over the title. You want to make sure the finance company's not on it. It's free and clear so that the person can sell it in the future. It's kind of just like that. So, hope that was interesting for you. Hope you learned something. I do want to talk a little bit about what to expect. As far as taking the test, well, you may end up, you're supposed to have maybe 80 questions and 30 questions, whatever your state says. Well, there might be a few extra questions. I know I got an additional 10 questions on my law portion of my test, and nobody told me about the experimental questions. So I rushed to get through it. But what I didn't realize was the experimental questions are kind of combined out of, like, for me, I was supposed to have 30 questions and I ended up with 40. I didn't know which ones were the experimental and which ones were the real ones. They do not count for you and they do not count against you. And the time actually stops, but you're so busy taking the test, you're not paying attention to the time. So just be aware, you could end up with more questions, and basically they're throwing questions in that they might possibly use in the future. So don't worry if you have a few extra questions on your test. And as far as what to expect, check your candidate guide. I know in PSI, Pearson VUE, in other courses or other state exams, they will tell you specifically what's on the test. They will tell you total questions, passing scores. And if you still have time, you're able to go back and make sure you've answered the questions. You can either mark them or maybe skip them. Don't ever skip a question. If you have to, I'm sure there's a button called mark or something similar when you take a test. If you're really not sure, just mark it, and then at the end you can actually go back. But here's the thing, don't wholesale change it. Why? Because you could turn a passing grade into a failing grade by worrying too much and overthinking. If you happen to see maybe like third question after you've marked something, the actual answers in the next question, well then by all means go back and change it. But my suggestion for you is go put in your gut feeling, and if you're just not 100% sure, maybe mark it, and then this way you can go back at the end. And now we'll have some questions. I'm going to turn it back over to CE Shop and they will help you out.
Wonderful. Thank you so much. As Gail said, we will be taking the time for some questions now. If you have any questions about titles and deeds as they relate to your national licensing exam, please do type them into the Q&A panel right there in your Zoom control panel, and our national real estate expert will be able to answer that for you. And Gail, thank you so much for taking the time to be here with us today. Your knowledge, expertise, and your willingness to share it with our student community is greatly appreciated. So now at this time, we'll turn it over to our live instructor. Thank you so much.